want to continue our discussion of this, and joining us to help us digest more of what happened this morning, we have Professor Maria Ledesma with San Jose State University. Professor Ledesma, thank you so much for joining us this morning. So you are obviously aware of the ruling that the court handed down. Before we get into the nuance of all of this, I just want to get your initial reaction. What did you feel? What did you think when you heard the decision?
Sure. It was not a surprise, but disappointing nonetheless. I think the composition of the court definitely signaled that this was the direction they were going to move in, and true to form, they did.
And so what do you think the path is forward? We just heard the president talk live. He says he's going to instruct the Department of Education to try and come up with ways compliant with the law where universities can continue to try and expand the diversity within their ranks, both in the administration and in the student body, but primarily the student body.
Well, this is new territory. Just as last year the court did with Dobbs, they are overturning close to 50 years of precedent that has upheld the use of race-conscious affirmative action. And so this is, again, new territory where post-secondary institutions are going to have to think through what are the options that are before them. In California, of course, we know what the future holds because the elimination of race-conscious policy happened in 1996 with the passage of Proposition 209.
And so, yeah, and we've been dealing with that, and there have been studies since indicating that perhaps maybe the diversity on campuses have gone down. At least it did initially. They're starting to rebound now. Do you think there are some best practices, some lessons learned here in California that other universities across the nation that are new now to this reality can pattern themselves after?
Yes, and as a matter of fact, in oral argument, at least one justice, Justice Sotomayor, directly called into the oral argument the history of losing affirmative action in California and how, despite the best efforts to have race-neutral alternatives, there really is no substitute for race-conscious policy. But in terms of best practices, you know, the UC system, other institutions have tried race-neutral alternatives such as considering socioeconomic status, geographic diversity, moving to test optional or not requiring standardized tests. But again, this is new territory for many post-secondary institutions.
Yeah, listening to some of the reaction coming in, those in favor of the court's decision today say this is a good day because it now, you know, puts everybody evenly before the admissions board of any particular university. But those who disagree with the court's decision say that, you know, that logic is flawed because the playing field itself was uneven to begin with, and this was something, affirmative action was something designed to try and correct that. I mean, what's your take?
Yeah, well, it's complicated because there's a lot of misconceptions and misunderstandings about what affirmative action is and what it isn't. One of the things that it is not is that it does not allow students to gain admissions if they are not qualified. I think that that's a major misconception that affirmative action puts a big thumb on the scale to allow students who have not met admissions eligibility requirements into post-secondary institutions. What affirmative action does is allow race to be one factor among many in the consideration of admissions for colleges and universities to take into account. So yeah, the framing around these policies unfortunately complicate how people understand them and the opinions around them.
So what do you say to those watching who perhaps aren't as steeped in this as you are, who think that the university, if they're looking at two equally qualified candidates before them and they have in the back of their minds that they have to meet a certain quota percentage of this ethnicity and that to achieve a diverse student body, will tip the scale towards somebody who satisfies that goal and disadvantages the other student, though they both may have been equally qualified?
Well, we begin with clarifying that quotas are illegal. They've been illegal since Bakke, and something that has continued through all of the cases, you know, up to today's. But I think that there is an important consideration to take into account that the elimination of race-conscious policy of affirmative action is going to be impactful for many people, not just students of color. The students of color who are beneficiaries, if you will, of a race-conscious policy, again, meet eligibility requirements, but many of those who go on to institutions that practice affirmative action will also very likely go on to pursue post-baccalaureate degrees where they are going to become teachers, lawyers, doctors. And so the impact on our future leadership pipeline is going to be massive, and it's going to ripple beyond, just communities of color.
I get the sense that a lot, and maybe you do too, that a lot of the arguments to overturn the affirmative action and in agreement with the court's ruling this morning perhaps were based on misinformation or misunderstandings of what affirmative action is. And if that's the case, do you think the justices in the majority on the Supreme Court based their ruling, again, on some misunderstandings about how this works?
Unfortunately, there is a pattern. If you look at the amicus briefs that have been filed in the University of Michigan cases and the University of Texas cases, and now in the Harvard and University of North Carolina cases, the overwhelming support from those who are submitting amicus briefs are coming in support of defending these policies. And those arguments in support of defending these policies tend to be more historically based, whereas those who critique the policies, and this is something that Justice Jackson notes in her dissent, are ahistorical. They are, not taking an account of the history and legacy of racism in the country.
Arguing sort of without context, you're saying, in these Friends of the Court briefs.
Correct.
So for a family, a mother and father, or perhaps a student, maybe in beginning high school right now, hears this ruling, sees that they may have a tougher go getting into college as a result, in their minds, what do they need to think about right now?
Yeah, well, unfortunately, the perception sometimes equals reality. There is a sense that those institutions that are going to do away with this practice are going to be unwelcoming to historically underrepresented students. And I think those students need to be reminded that their presence is very much needed still in these spaces, that, we still require a diversity of experience in many ways. I think one key thing to understand, to take away from today's rulings, is that while the court has decided to end affirmative action, to do away with it, it doesn't mean that the problem of inequitable access to educational opportunity has been solved. What it means is that one of the most powerful tools to integrate the nation's most selective institution has been taken off the table.
We were talking earlier with experts this morning who say that the one good thing we can hopefully hope for going forward is the fact that in today's times, the vast majority of businesses, the vast majority of organizations, the vast majority of universities now understand and appreciate and celebrate the value of diversity within their ranks. Do you get the sense that despite the court's ruling today, that universities going forward will still work to keep the student population diverse, that they're not looking at this like oh great, we don't have to worry about this anymore?
Well, I mean, what you just said in terms of that recognition of the value of diversity, especially in a global marketplace, again, was overwhelmingly voiced in the front of the court briefs from, a variety of institutions like the military, Fortune 500 corporations, other business leaders, obviously higher education leaders, but it seems to have fallen on deaf ears. So I hope that these institutions still hold these core values to be true, but in terms of what practices are to come, I think that that's, again, where we're in new territory.
Dr. Ledesma, thank you so much for joining us this morning and helping us understand the ruling of the court today.
Thank you.